SJC-12420, Commonwealth v. Robert Honsch.
Okay, Attorney Fishman, good morning.
May it please the court, Neil Fishman here for Robert Honsch. I'm going to go through the arguments I made in the appellate brief with the exceptions of the argument pertaining to the fingerprint evidence and the third-party culprit, which I don't think I can improve upon in the brief. I'd be happy to entertain questions.
Excuse me, before you get started, this is Justice Cipher. Can I ask you a question? So I can understand your argument in the context of the theory of defense at trial. Can you articulate what the theory of defense was?
The theory of the defense was that the defendant had a psychological the defendant maintained his innocence, and the defense was that the defendant had some sort of psychological break that explained some of his conduct after the homicides.
Okay, thank you.
So if this court does nothing else, and I hope it does more, I think it has to either reduce the verdict or reverse the first-degree deliberately premeditated murder conviction.
Well, let me ask you about deliberate premeditation and the use of a firearm. We have evidence of 2 to 3 shots with a firearm, correct?
That's correct, Your Honor.
I thought our law was fairly clear that when you shoot someone at least multiple times, it's premeditation.
Well,
Are you aware of any cases we have where we say no premeditation with a gunshot wound?
well, let me put it this way, Your Honor. Those three shots, not all the three. By the way, it could have been 2 to 3. So that's
I said 2 to 3.
Yeah.
And we're looking at it at like most favorable, right?
That's correct, Your Honor.
All right. So tell me a gunshot case where we say no premeditation.
Well, I don't know of any such case, Your Honor. But however, I would suggest that I don't see how there's any evidence of cool reflection.
How about the towel?
Pardon me?
How about the towel?
Well, to me, Your Honor, that strikes me as speculative that the towel was used to muffle the gun. Of course, that's.
But weren't there holes in the towel with gunpowder on there?
There was, Your Honor. But again, I think it's speculative that was used to muffle the gunshot.
There were shots in the head too, right?
It was unclear whether it was one bullet to the head or more than one because there's injury to the victim's
frankly,
jaw.
when you have a use of a firearm in what appears to be an execution, I don't get how it's not premeditation.
Well, Your Honor, just again, there were no eyewitnesses to the crime. There was no evidence of motive. There was no evidence, again, of any sort of reflection, any period of reflection, certainly not cool reflection.
Can happen in seconds.
That's true, Your Honor. That's true.
I think the strongest argument about premeditation, because premeditation is really probably not your best argument with the time that you have, but probably the strongest argument is, lo and behold, look, the wife's dead, and my goodness, the daughter's dead too, also in a desolate area in a different state, shot in the head, and my goodness, he doesn't even remember they existed. You have to say that they were going to Australia with him, and then he goes to Africa for a few years and comes back and has a new name. So it seems that the sufficiency issue is really, in many ways, dependent on Elizabeth. And if you took Elizabeth out, you'd have a sufficiency problem. And the evidence as it relates to Elizabeth is hardly overwhelming. And so my concern that I'd like you to talk about, that might be a better argument than premeditation is it getting a little circular here that, oh, we know that he killed the wife because he killed the daughter. Well, we know he killed the daughter because he killed the wife.
Your Honor, I could not have said it better. With regard to the daughter, the entire case is built upon the daughter because there's insufficient proof tying him to the wife's murder. Here's what they have insofar as they have arguably, and this is a reach, he's present. Now, how is he present? Well, he had sex with his wife. We know, but I don't know if that puts him anywhere near the campground. How else might he have been present? Well, there's a cigarette. Well, this is the 90s, and he smoked, and lots of people smoked. That's it.
Well, you got the consciousness of guilt.
Very, yes. As I put in the brief, not insubstantial consciousness of guilt evidence, but as Your Honor knows, that's insufficient as a matter of law.
So you basically have, in your view, a very thin, direct case, but lots of misconduct evidence coupled with consciousness of guilt evidence.
Well,
The misconduct being the death of the daughter.
yeah, well, yes. So lots of consciousness of guilt evidence. There is, as Your Honor went through it, there's the we're moving to Australia bit and the moving to...
This is an overwhelming case of consciousness of guilt, but that's not enough, as we've said.
Exactly, Your Honor. And just, there's, crucially, there's nothing tying these murders together other than the fact that that the wife and daughter are related.
Well, so that's what ties it together. The issue for me is what is the strength of lack of strength of Elizabeth? You know, this is the brides in the bathtub. This is the doctrine of chances. Oh my goodness, lo and behold, about the same day, the mother and daughter died. Both, wow, in desolate parks that he's been to and denies going to. Another park that he's been to. But the Commonwealth case is nothing without the foundation of Elizabeth. So, which is good for you. But you gotta tell me something about attacking the strength of the case against Elizabeth.
Well, Your Honor, I'd be delighted to. And first of all, I do want to take a moment to say exactly what Your Honor is saying. That when there was a motion for the required finding, the ADA said, well, implicitly conceding that there's not enough evidence to convict him of murdering Marcia without the evidence of Elizabeth. So the entire case depends on the evidence that he that a rational.
Preaching to the choir.
Okay,
Tell me the problem with
so the
Elizabeth.
problem with Elizabeth are manyfold. Most importantly, that the fact that it was admitted as identity evidence is a miscarriage of justice. This is a classic example of, in one of the cases they say that the problem with identity evidence is it is propensity evidence.
It's carrying a much lighter load. That's why it's not prior bad acts to show conformity therewith. That's why it's a category of a non-propensity purpose, because the propensity is carrying a lighter load, and the lighter load is, lo and behold, doctrine of chances.
Well, Your Honor, the case law from this court on when you have, in this one, I would be remiss if I didn't say we don't even know, is this subsequent bad act, is it prior bad act? So I call it throughout the brief other bad act.
Well, it's uncharged misconduct. It doesn't have to be prior. It could be post.
I understand, Your Honor.
We don't have a temporal.
But it does go to its probativeness. And as far as proof of identity is concerned, the case law out of its court says what we're really looking for is a modus operandi, a signature crime. It's got to be unique and distinctive. And the cases, there are cases where this court has reversed because...
Is it unique and distinctive when it's the mother and daughter who disappear at the same time?
That's not a signature element, Your Honor. That may give you something with regard to common scheme and plan.
I get what you mean by, it's the person who robs banks wearing a clown outfit. That's the
That's a good example, Your Honor. And, I think Briscolas, which I cite liberally in my brief, but I didn't delve into the facts, and I think I was remiss in doing that. I think that really helps you here, because there you had a sexual assault conviction where the previous sexual assaults had no signature aspects. They were the part and parcel of sexual assaults. And I would suggest to this court that a gunshot wound from a medium to large caliber weapon is very sadly, that's not a signature element in a homicide.
But if you put
Certainly not.
if you put it all together, right? Mother, daughter, both shot in the head, right?
That's correct, Your Honor.
And
remote areas.
yeah, remote areas, same time. I mean, so if you put it together, you do sort of begin to see that there's.
Well, the best you got, I think, would be some sort of evidence of common scheme and plan. But I would still.
Wait a minute, that's not they can call it common scheme or plan. It's not a common scheme or plan case.
It's an identity case, Your Honor.
It's using the doctrine of chances as it relates to identity, with the similarities being everything that Chief Justice Budd just pointed out. And is it enough? And I guess I'm getting back to the same question I've asked a couple of times, which is instead of telling me that it's not non-propensity, because if it's propensity, then you win and it shouldn't have been admitted, and you don't have to answer this next question. If it's non-propensity identity through doctrine of chances and similarity, do we have to be concerned about any frailties in the case against Elizabeth? And let me help you out with that, okay?
Yes,
you
sir.
You got somebody else's semen on the vaginal swab. You've got a fingerprint that came in, even looking at Commonwealth versus Fulgham with more certainty than it should have.
Correct, Your Honor.
And I understand the evidence that it was the defendant, but the evidence is not overwhelming that it was the defendant.
I agree, Your Honor. I think I would go further. I think the evidence that it wouldn't be enough to satisfy a rational trier of fact. I don't think that he killed Elizabeth. We have a hair. It's mitochondrial DNA. It's not nuclear DNA. Nevertheless, it's DNA evidence. But it's a hair that even the experts said could have gotten there for any number of reasons. And of course, they lived together. And the fingerprint evidence, which when I came out here, I said I'd prefer to rest on my brief for that because it's somewhat involved. But the examiners were cognitively and contextually biased. They knew quite a bit about the case. It's a very emotional case. And they're using a method that this court is now seriously in disfavor with this court and with the scientific community. And they're,
The fingerprint's not disfavored at all. It's that it can't be in terms of certainty, and that even if the defendant doesn't object, you just can't have certainty. It's not disfavored. It's just not a hard science.
I would just say, Your Honor, thank you for mentioning again. I think both witnesses said it was to a certainty, and the ACE-V method is now disfavored under Gambora. I would submit that that's the law of this court. So again, I think the evidence that he killed Elizabeth is insufficient to satisfy a juror beyond a reasonable doubt that he killed her. And again, just tying into your honors theme, the circularity of this.
The question. So you got the sleeping bag issue, and you got the consciousness of guilt issues that he hasn't been to the place where the bodies are when he had other times, and off to Africa for a few years, new name, all that stuff. But this is the circular problem that the DA is going to have to talk about. But you don't look at Elizabeth in a vacuum, because Marilyn, is her name Marilyn?
Marcia.
Marsha, thank
yeah.
you, I'm sorry. Because Marsha's killed within a number of days in a similar circumstances in a state where she doesn't live. So for Elizabeth to be sufficient, you got to look at Marsha. And the DA is going to have to help me understand why this isn't a big circle. But you don't look at Elizabeth in a vacuum. You have to take into account Marsha.
Well, I would say to that, I would note for Your Honor that Your Honor has spoken about the similarities between the crime. I think they're somewhat thin. You have a gunshot wound to the head from a medium to a large caliber weapon, which is hardly unusual. But Elizabeth is assassinated. Marcia is shot from a distance.
Is it unusual? I mean, the fact that these two, a mother and daughter, go missing at the same time, isn't that a tough thing to get over?
Your Honor, it may be probative of. There may be an argument that it's probative of that the same person killed them. I'm going to wait on the prejudice element there, but it's not probative of identity because of the law of this court, because it's not a signature crime. It's very far from it. It's somewhat, very sadly, it's somewhat routine. And but getting to the prejudice element here, this is, this court is well aware, when we're discussing other bad act evidence, if it's overwhelmed, if the probative value is outweighed even slightly, not substantially, but just outweighed by the potential for unfair prejudice, then it should be excluded. Well, this is, if any case is this is the case.
But what do we do with the argument raised by the prosecution or the Commonwealth here that, but for the fact that Elizabeth was found this side of the border and Marcia on the other side, this would be tried together?
I don't know, Your Honor. Having dealt with some joinder issues in previous cases, I found the analysis to be pretty much the same. So that you might have a good argument for severance or lack of joinder. I forget what the terminology would be, but I do want to return to the prejudice. I want to talk about the photos. The Commonwealth did me a favor and pointed to which photos I was referring to, and I think the ones that I really would ask your court to consider are Exhibits 51. That's the face of the young girl at the crime scene. 70, that's her clothes on the autopsy table. And 82 through 85, that's her face at the autopsy table. Now, this would, arouse the emotions of any juror. But what's unique here is the defendant's not on trial for Elizabeth's murder, but he's defending himself left, right, and center. The entire focus of his defense is to prove that, or to raise reasonable doubt that he killed Elizabeth, because if he does that, then he gets acquitted of Marcia. And that is the problem that Justice Lowry is talking about. It's quite a Kafkaesque situation. It's additionally Kafkaesque because he's not allowed to bring in any third-party culprit argument with regard to Elizabeth. He's confronted with these photos of her. He's confronted with the mitochondrial DNA evidence, the fingerprints on the bags. So the entire defense is really about Elizabeth, and it's nominally about Marcia. And I think that's why a reversal is necessary here, Your Honor. If the court doesn't have any other questions, I'll rest on the brief.
Okay, thank you.
Thank you.
Okay, Attorney Lynch.
Good morning. May it please the court, Travis Lynch, Assistant District Attorney on behalf of the Commonwealth. I think to answer Justice Lowy's question, why isn't this just circular? The key point here is that the defendant told the victim's relatives that Marcia and Elizabeth were going to Australia at a time, inferably, when Marcia and Elizabeth were already dead. That's why this isn't just completely circular. And I think that's really what that statement by the defendant is what really ties the two murders in the two incidents together.
Is there any concern that what ties together, I'm not sure that's all that ties together, but that ties together is consciousness of guilt? Consciousness of guilt can only take you so far, as you know from our consciousness of guilt instruction.
That's
And
correct.
Commonwealth versus Tony.
Right. So is there a concern? I mean, I think the rule simply is you can't be convicted solely based upon consciousness of guilt evidence.
Yes,
This-
my question in response to the first thing you said out of the box is, if what makes it not circular is consciousness of guilt, did that cause us any concern?
I don't believe so because, again, the sufficiency rule is just that you can't be convicted solely based upon consciousness of guilt evidence. I mean, also, I would respectfully submit that it's not just for consciousness of guilt. The judge also, I believe, found that it was admissible for common scheme and plan. So if it's common scheme and plan, then we're out of the question of whether we're convicting him solely based upon consciousness of guilt evidence. Also, we're not convicting him based solely on consciousness of guilt evidence because the palm print evidence is not consciousness of guilt, it's other bad acts evidence. Again, I believe you also can't be convicted based solely upon other bad acts evidence, but you've got consciousness of guilt, other bad acts, and then you have some circumstantial evidence showing opportunity. Again, the question is not whether the jury was compelled to find him guilty, it's whether a rational finder of fact could have found him guilty. So on the question, again, I think we've already gone over this, why there's sufficient evidence to establish that the defendant was the person who committed this murder. And the court has already gone over in great detail why there's deliberate premeditation. The fact that there's inferably 2 gunshot wounds to the head is by itself enough to get us to deliberate premeditation, plus there's the towel.
What about the balancing, because this is uncharged misconduct on steroids, obviously the death of the daughter as well.
Mm-hmm.
And if you do a balancing, you have to be very careful because of the amount of prejudice. And so can you speak to the balancing done by Judge Sweeney?
Yes. So essentially what the judge found was this is a double homicide. The balancing of the prejudice, I think you have to take into account the fact that the judge was constantly reminding the jury over and over again, you can't use this evidence, you can't use the evidence relating to Elizabeth by itself to convict the defendant. So the judge articulated the defendant's concern below as the jury is just going to stampede the defendant here because of this overwhelming consciousness of guilt evidence. But they're told repeatedly, you can't do that. And the instructions are very plain. They were repeated over and over again. It's stated in the voir dire of the jurors, which I believe took 4 days. Most of the days of the trial, the instruction was given.
Was the voir dire on both consciousness of guilt and uncharged misconduct, or just on uncharged misconduct?
I put in the uncharged conduct instruction in the voir dire. I believe that they mentioned.
We'll look for it.
Yeah, I believe it. I believe in the voir dire they talked about consciousness of guilt as well. So the jury's being screened here to avoid the problem that the defendant has identified. And again, we have to presume that the jury followed their instructions. And it's stated.
Was this during the attorney voir dire era, or no?
I think the attorneys asked questions. So.
How about this concern? So let's assume there's a non-propensity purpose for the Elizabeth murder as it relates to prosecution where Marcia's the victim. And let's assume, although we've got to wrestle with the point Justice Graziano raised about when the prior bad acts sort of dominate like they did in Commonwealth versus Dwyer. But let's even put that aside for the moment. Is there any concern that what's driving this here as it relates to sufficiency and ultimately, if you pass sufficiency, to any other errors that might exist, that it all comes down to relying on a homicide that might not be enough to, as it relates at least to a burden of persuasion, as it relates to Elizabeth. Let me say it simpler.
Thank you.
There'd be no case relative to Marcia if it weren't for Elizabeth. And the case against Elizabeth, even if it would satisfy a burden of production, might have some problems with a burden of persuasion or proof beyond a reasonable doubt.
So I take your question to be, we're assuming that the evidence as to Marcia without the Elizabeth evidence is insufficient, is that?
My view.
Okay, well,
Yours?
no, it's not our view.
Tell me about that then, maybe.
Well, again, when you take the essentially, when you take the Elizabeth evidence out of it, it takes away a stronger link, forensically to the defendant.
Okay, just tell me why it's sufficient without Elizabeth.
Because the defendant still has opportunity to kill Marcia, and he still tells the relative, even if you take Elizabeth out of it, he still tells the relatives Marcia's going to Australia, and then the defendant still leaves. We still get those statements, Marcia's going to Australia, even without Elizabeth's evidence coming in. The defendant still goes to Africa regardless of whether any of the evidence relating to Elizabeth comes in. The evidence is still sufficient.
Can I interrupt for a moment, please, just to follow up with Justice Lilly's question? Can you identify the evidence against the defendant that's not consciousness of guilt evidence and not prior act evidence as related to Elizabeth?
He's familiar with the area. He's familiar with the Talon State Forest area. There's the semen evidence which suggests that he had access to Marcia before, not long before she was killed.
It's a little bit, give me this, it's at least a little bit questionable whether you satisfy sufficiency without Elizabeth. I'm not sure you do. But if you don't, should I be concerned about this circular issue that ultimately it might be Elizabeth that satisfies sufficiency when there might not be a particularly overwhelming case as it relates to Elizabeth without Marcia?
I'm not aware that there's a case that says that we parse it out like that. Again, we're looking at it's an interesting academic question whether this case is sufficient without the Elizabeth evidence. But quite frankly, we don't have to prove it that way. And so that would be my answer to your question. It would be much more difficult, obviously, if we didn't have the Elizabeth evidence. I would agree that it is much more difficult without her.
But that's not the case that was presented to the jury. That's your point.
Right. We have to take all the evidence in light most favorable to the Commonwealth. We don't just parse out, we don't.
If we determine that the Elizabeth evidence was admissible as uncharged misconduct, right, and it wasn't overly prejudicial, or if we do the balance and then we look at what was presented to the jury.
Right, exactly. And the point's well taken that we can't convict based solely upon other bad acts. It's well taken, we can't convict based on consciousness of guilt. We've got other bad acts, we've got consciousness of guilt, it's all a
You can't convict it
totality.
based upon the totality.
It's a totality, exactly.
So even if there weren't hypothetically enough sufficient evidence to show that the defendant killed Elizabeth and there was not sufficient evidence that he killed Marcia, you're saying together plus the consciousness of guilt somehow ratchets it up to beyond a reasonable doubt as to Marcia?
Yes. As an aside, I would note the defendant was also convicted in Connecticut of the Elizabeth murder. That's not in the record. I think it's noted in a few of motions to enlarge. But he's been convicted there too of killing
Well, if he
Elizabeth.
wasn't, it wouldn't be admissible in Massachusetts under our law.
No, actually, he was convicted after this
Oh, it was
trial.
afterwards.
He was
Okay.
convicted last year. Not that, that's neither here nor there. That's just an aside. Unless the panel or unless the quorum has any additional questions with respect to anything raised on the appeal,